The House Judiciary Committee will come to order. Madam Clerk, will you please take the roll?
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Hope. Here. Arbit.
Present.
Devendorf. Here. Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 13 members present. You do have a quorum.
Thank you. I have a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. And those minutes are now approved and adopted. And today we are going to be hearing testimony on two separate packages. We will be voting out one. I would first like to take testimony on House Bills 4120 through 4125. And Representative Rogers and Rangans, would you like to tell us about the bills?
Good morning, members of the House Judiciary Committee. Thank you, Chair Breen, for the opportunity to testify this morning. It is an honor to be here today with Representative Rangans and Heath Lowry from the Michigan Coalition to End Domestic Violence. The 6 bills that we are speaking to this morning are part of the 2023 bicameral bipartisan sexual assault prevention and education bill package. I would like to start by asking you a question. How much is a little girl worth? I will come back to that later. As you may recall, the 99th legislature introduced 40 bill concepts during the 2018 investigation into the MSU Larry Nassar scandal. Many important pieces of the package have already been signed into law. 6 of them are being reintroduced this term to make sure that we finally address the critical failings in our state system that allowed this decades-long travesty to unfold. All 6 bills have been passed out of the House chamber with overwhelming bipartisan support in several past terms. We owe it to survivors throughout the state to finish what we started and make Michigan a leader in ending sexual abuse once and for all. To survivors, I would like to say this: your voices have not been forgotten. As we have seen in recent events, these types of instances are not isolated to one college or university, and we should not wait to act on these necessary reforms any longer. In fact, some of this testimony may be a trigger for some in this room who may have experienced sexual violence ourselves. I'd like to give a brief overview of my bill along with 4 others, and then Representative Rangans is here to testify on her bill. I represent House District 41, which includes Kalamazoo. Why I mention this is because one of the women to come forward was Rachel Denhollander. She was born and raised in Kalamazoo. Denhollander told the MSU Police Department in August of 2016 about her abuse, filed a Title IX complaint with the university, and then shared her story of sexual abuse with the Indianapolis Star. Denhollander said Nassar sexually assaulted her when she was a 15-year-old gymnast and sought treatment for low back pain. Denhollander came forward years after Nassar first abused her, which led to a floodgate of hundreds of other women who came forward with similar allegations. At least 7 other young women told someone about Nassar over a 20-year period before Denhollander did likewise. But her complaint was the first to catch traction and gain national attention. As we know, Nassar admitted guilt in a plea agreement and is now imprisoned for the rest of his life. Before he was sentenced, more than 200 women gave testimony about his abuse in 2 courtrooms over 9 days in county courts near Lansing. In asking the judges to impose the maximum sentence on Nassar, Denhollander said, "How much is a little girl worth?" She then answered her own question. These victims are worth everything. My bill, House Bill 4120, is a reintroduction of my bill from last term, 4854, and is identical to the language before, which would require that comprehensive training materials be offered for individuals who are required to report suspected child abuse or neglect. The intent of my bill is simple. We must ensure that mandatory reporters are trained on how to report suspected child abuse or neglect. As we learned from the brave impact statements given by the survivors of Larry Nassar, these young girls and women often told adults of the abuse they suffered at the hands of this monster. So many survivors who speak up are either not believed or the adult they told failed to report the sexual predator, which allows them to continue assaulting and abusing for who knows how long. In the case of Larry Nassar, it was 30 years. Currently, DHHS is required by law to make training available. However, we need to ensure that the material is actually getting to the mandatory reporters. So my bill would require employers or organizations to provide these comprehensive training materials to paid workers or volunteers who are mandatory reporters. Research has consistently found that professionals fail to report over half of their suspicions of child abuse to the authorities, and this finding proves that a clear policy direction to focus on the training is very much needed. These individuals need to be prepared to act when they know or suspect child abuse or neglect is happening or a sexual assault has occurred. Requiring that this material is actually provided to the mandatory reporters is an important step to help stop predators from continuing heinous acts against children. The bill would allow DHHS to build upon what is currently made available in consultation with the Michigan Domestic and Sexual Violence Prevention and Treatment Board and the Michigan Coalition to End Domestic Violence in order to ensure these materials remain up to date. As a healthcare provider myself, who is a newly mandated reporter, I personally support the intent of this bill. We also have House Bill 4121 in the package, which I think after my remarks the chair may address. House Bill 4122, Representative Hope's bill, provides the penalty portion for the disciplinary hearing on an individual's license by providing for a permanent revocation of the license for a licensed healthcare professional whose disciplinary subcommittee finds that they have committed a violation of Section 90 of the Penal Code that prohibits sexual assault under the pretense of medical treatment, and that one is 4122. This bill is the enforcement component of 4121, which would remove criminal medical licenses who would abuse their authority before they could spend years preying on victims. With the requirement to hold a licensing hearing under Chair Breen's bill and the penalty of the license revocation under this bill, we will have a durable and effective process for ensuring that no one who harms a patient sexually while pretending to practice medicine can inflict their abuse on more victims by simply moving to another town and reopening their practice. House Bill 4123, Representative Filler's bill, directly addresses the Larry Nassar situation and would prohibit an individual from abusing their authority to prevent a victim of a sexual assault or a child abuse from reporting that crime to the appropriate authorities. Individuals in positions of professional authority are given a great deal of trust, and with that position of power, the ability to use it to manipulate others. Doctors, teachers, coaches, or anyone in a position of authority could protect themselves or others from the consequences of their actions by threatening or coercing a victim from reporting the crime committed against them. This bill amends the Michigan Penal Code to include the abuse of that position of authority to prevent reporting a sexual assault or child abuse as a misdemeanor with a 1-year sentence and a $1,000 fine. If the violation includes an attempt to commit a further crime or a threat to kill or injure a person, then they would be guilty of a felony with a 10-year sentence and or a $20,000 fine. House Bill 4124. Not everyone feels comfortable reporting crimes that they may seek to report an assault that occurred on the grounds of or in connection with a University of College program. And as such, Representative Glanville's bill includes the same provisions as Rep. Filler's bill, but prohibits the abuse of authority to prevent reporting of an alleged violation of a criminal sexual conduct code or child abuse to a Title IX coordinator. Young adults at a post-secondary institution can be vulnerable to abuse as the power imbalance between a student-athlete, pupil, intern, or other program participant, and employees of the university who have control of their academic futures or athletic participation creates the potential for a bad actor to prevent someone from coming forward when they have been subject to such assaults. If a student comes forward and reports to a Title IX investigator, no one in a position of authority should stand between them and justice. This bill ensures that an individual who abuses that authority is subject to the same penalties as described in Representative Filler's bill, HB 4123. Chair Breen and members of the House Judiciary, again, we sincerely thank you for making this package a priority again. And I am happy to take any questions either now or after Representative Reingans testifies on her bill.
I don't see any questions. Representative Reingans?
Great. Thank you, Madam Chair, and thank you, committee members, for letting me be here today to testify. I'm here to speak on HB 4125, which would prohibit schools from expelling or suspending a student for more than 10 school days for reporting being sexually assaulted. As you've heard, students are apprehensive at times to report being sexually assaulted, and this bill specifically addresses that concern, that they might be concerned about reporting and being expelled for reporting. The intent of this bill is to protect students from being expelled or suspended for reporting being assaulted. We know that expulsion has long-lasting impacts on students, and we believe that adding that penalty on top of the traumatic experience of sexual assault is pretty extreme. The Center for Educational Performance and Information, CEPI, does not currently track, it does track data around expulsions, but not explicitly expulsions resulting from reporting being sexually assaulted. So we don't have the exact number of cases that this happens to every year, but we do know this happens because we have reports to the statewide Student Advocacy Center about these situations that have been happening for years here in Michigan. This is a center, it's a statewide group that helps struggling students who are out of the classroom to get back into the classroom. So this bill would intend to add protections to those students for reporting being assaulted. This is a reintroduction of a bill introduced by Representative Yusuf Rabi in 2018. It has a history of bipartisanship and unanimously passed the committee in 2018, and it passed the House 98-10 back in 2018. Perry Stone Palmquist is a nationally recognized expert who works at the Student Advocacy Center here in Michigan and shared in testimony in 2018 a story of a girl who reported being assaulted at school, and there were multiple circumstances that contributed to this situation of sexual assault, and the school ultimately expelled her for 180 days for reporting the assault, and some of the factors that the school implied were related were factors that were used to expel her, such as being in the wrong part of the building. And that's really an extreme example and an extreme punishment for a student who was trying to report being assaulted to people who are supposed to be supporting her in school and help her work through that and be able to remain in school. We know that these suspensions and expulsions increase school dropout failure and juvenile justice involvement, and it negatively impacts the perception of school safety and the school climate. So undergoing both an assault and being expelled really can worsen a victim or a survivor's mental health, self-esteem, and school performance. Schools should be a place where students feel safe. Coming forward to report being assaulted takes courage on behalf of the victims and the survivors. If a student tells a school administrator or a staff member, they're looking to be heard and supported and believed. And instead of receiving the support they need, sometimes our state allows for them to be expelled after one of the worst things that could have happened to them. This is unacceptable. Please support HB 4125 so students can feel safe coming forward to report a sexual assault.
Thank you, representatives, for bringing these very important bills forward again, and thank you to the other sponsors in the room. I see Representative Filler back there. I myself am a sponsor of one of the bills on this package, and just to clarify for the committee, my bill is the one that would, after a conviction, a licensed health provider would have to face a disciplinary hearing no matter what. Are there any questions from the committee? Yes, Representative Sergelew.
Thank you. Just a quick comment, actually. It seems hard to believe that, this would actually be happening. But this actually happened to a friend of mine's grandchild about 10, 15 years ago. And I, found it hard to believe and tried to follow up and ultimately was not able to do anything about the situation. But thank you. Thank you for putting this bill forward. And it did change her life in a very negative way. So thank you.
I'm so sorry to hear that.
Representative Fink.
Thanks, Madam Chair. I do want to. My question is for Rep. Reingans on 4125. I'm trying to understand. I mean, I think I can imagine circumstances where this question of expulsion, or I guess where this issue might come up. But I wonder if you could just give us like I mean, is the idea here? I mean, you use an example of a student being in a place they're not supposed to be in a school, which you wouldn't normally expect one incident of that to like result in an expulsion. But I mean, would it be like a mutual fight that happens after the? I mean, what kind of circumstances are we imagining here that would actually cause a school to, except for the circumstance of the person being a victim of a sexual assault, contemplate expulsion? Does that question make sense?
Yeah, so I think based on what I've heard in conversations with stakeholder groups, there are potentially instances where there might be retaliation or something many weeks later, or things like that, from a student who has been assaulted at school, maybe retaliating in some way. But that would be a completely separate incident from the actual sexual assault. And so since there's a little bit of gray area right now in our law, we just want to make sure that we're adding it clearly that a student being sexually assaulted, that's explicitly prohibited as a way to expel somebody for such a long period of time or suspend them for more than 180 or more than 10 days, excuse me.
Can I ask a brief follow-up?
Absolutely.
So, do you? The language used here in this bill is an action that the pupil took arising out of an incident, which again makes me think, well, if the victim winds up in a fight or something, that would not be an appropriate reason. If a fight with an assailant would not be an appropriate reason to say, well, you were in a fight at school, so you're suspended for a month or whatever. I understand what that would mean, but do you have any other commentary on what you believe the phrase "arising out of" means? What would it, what would kind of be in arising out of, and what would not be in it? Do you understand my question?
So this is a good question. I have received questions about this particular phrase of the bill, and we're working to see if there's any sort of specific clarity we can add to this that would really define what kind of things would fall into arising out of versus not arising out of. I don't know if you have a copy of the bill in front of you, but there are some specific actions listed in here that would still be allowable. A student would still be allowed to be expelled if they were convicted of, plead guilty to, plead responsible for, adjudicated responsible for a variety of other kinds of physical assaults. And then there's also description in here about a Title IX investigation. And as you know, there are many factors considered through a Title IX investigation, which we're hoping that this bill clarifies and adds into law that really this needs to happen, this investigation. And I have heard a concern about what if the student lies to avoid expulsion, and that's addressed here in the bill too, as written.
Okay, thank you.
Thank you.
Representative Devendorf.
Thank you for bringing these bills up. I've done a lot of work in the community and also with the Nassar survivors, so I truly appreciate this, but also anything related to accountability and fairness and accountability related to sexual violence. You did just clarify what I wanted to make sure was clarified, which was that if a survivor were to contribute in any violent way in response, even if it's in response, it is not covered by this bill. They are not protected from expulsion. So I appreciate you clarifying that, and I'll list aggravated assault, felonious assault, assault with intent to commit murder, assault with intent to create bodily harm, assault with intent to maim, attempted murder, homicide. So we really aren't leaving room for folks to create harm in response to their trauma, and I appreciate that, but I hope that is clarified for people.
Thanks, Rep.
Representative Arbit.
Thank you, Madam Chair, and thank you to my colleagues here for bringing this package together. I just wanted to address a little bit of a question that was raised previously. I appreciate you bringing this package forward because I think historically the scales have been tipped so far in favor of not taking action, of sweeping these types of incidents under the rug, and I think taking action even when we can say, this type of harm may be theoretical, right? But the fact is that it's not theoretical, is that we have had, for as long as this country has existed, right? We have had sexual violence. For as long as humanity has existed, we've had sexual violence. And right now, what we are doing and what you are doing and leading in this package is rebalancing the scales in support of and to defend victims and survivors. And that is so meaningful, not only to me but to so many people who have experienced and been have survived sexual violence. And so I am grateful to both of you and to all the sponsors of the package for bringing this forward. And I think it could not be more important and vital. So thank you.
Yes, Rep. Rankins?
I just want to say thanks to Rep. Rogers for helping lead this package in the House and partnering across the Capitol. So thank you for doing that.
Thank you very much, Representatives. Appreciate your time, and hopefully we'll be able to vote these out at the next Judiciary hearing. I'd like to call up now Mr. Heath Lowry, representing the Michigan Coalition to End Domestic and Sexual Violence.
Guess I'll sit over here. Good morning, Representatives. As was previously stated, my name is Heath Lowry. I'm a staff attorney, and I'm here today to represent the Michigan Coalition to End Domestic and Sexual Violence. We are a membership nonprofit organization that consists of over 70 service providers across the state representing every county in Michigan. Our member programs provide wraparound sexual assault services, shelter, therapy, and a number of other services designed to be survivor-centered and to address the harms done by sexual and domestic violence. I'm here today to ask you to support this package of bills, 4120 through 4125. Advocates within our member programs, my colleagues at the Coalition, and I work every day with survivors in systems that often ignore them or don't understand them, or in the worst cases, punish them for their victimization. This package is a significant step towards a society that not only hears survivors, but addresses their victimization and their humanity properly. As an organization that regularly trains mandated reporters, we see the effects of uncertainty amongst mandated reporters in various professions. It often leads to either over-reporting or under-reporting. And in either instance, survivors lose because they are either ignored by a system or unable to be properly addressed by a system that is overburdened. And Bill 4120 would create a mutual understanding amongst mandated reporters and allow for uniform responses to reports across the state. 4121 and 4122 would ensure that those who violate the special relationship between a medical service provider and a patient are never able to repeat that harm. A violation of dignity, especially within the confines of a doctor-patient relationship, can lead to lasting damage and often leads to a long road for recovery and regaining of trust. And this bill shows the value in strengthening and supporting that relationship and the importance of preventing future violence. House Bill 4123 and 4124 both seek to reduce the dramatic underreporting of sexual violence. For a variety of reasons, 2 out of every 3 sexual assaults go unreported. And one of the many reasons is the misapplication of authority by the perpetrator or some other official within the system. This often silences and re-traumatizes survivors during what is often the worst time in their lives. Those who have been given authority over others must be held to a higher standard, and this bill recognizes that obligation. These bills recognize that obligation. And finally, the delicate balancing of 4125 acknowledges the significant amount of research related to trauma response, especially when related to sexual violence. Survivors often take actions that may seem counterintuitive to an outside observer, but every person responds to trauma in a different way. And trauma responses can often feel involuntary to the person experiencing them. In school children, trauma may result in actions that violate some school regulation, whether it's being in the wrong place or even maybe vandalizing someone's locker as a means of reporting. Punishment beyond the scope of what is laid out in this bill would just compound the trauma and harm caused to the survivor during the initial victimization, and just would deter future survivors from reporting in the system. The coalition has been honored to work alongside the sponsors since the introduction of these bills, and we thank you for your time today, and we ask that you support this bill package, and I'd be happy to entertain any questions.
Representative Edwards?
Thank you, Madam Chair. I do have a question regarding 4125. Does the package include exception for fraudulent claims?
Thanks, Rep. Edwards. Yes. So at the very end of the bill, it says a pupil, the expulsion limitations and suspension limitation does not apply if a pupil, if any of the following concerns are met. A completed Title IX investigation determines by clear and convincing evidence that the report of sexual assault is conclusively false. So if there is a Title IX investigation that concludes that, then there would be an exception for that.
Thank you.
And I would go further to say that false reporting, while often expressed in these sorts of situations, is vastly outweighed by true reports that are not taken seriously.
Thank you, everybody, for your testimony today, and I look forward to bringing these bills up again.
Thank you.
I have some cards of people who wish to support the bill but not speak. Matt Black from the Michigan Academy of Family Physicians supports the bill. Yusuf Rabi from the Michigan Nurses Association supporting the bill. And Tom Hickson from the Michigan Catholic Conference also supporting the bill. We also have two emails here, written testimony from the Michigan Junior League supporting House Bills 4120 through 4125. And also Jess Averill from the Michigan Domestic and Sexual Violence Prevention and Treatment Board, supporting House Bills 4120 through 4123. We are now going to take up the ERPO bills, House Bills 4145 through 4148, and Senate Bills 83 through 86. Sheriff Fanes from the Michigan Sheriff's Association wishes to make a statement but will not be taking any questions.
Good morning, Madam Chair and members of the committee. As stated, my name is Dan Fanes. I'm the Deputy Director for the Michigan Sheriff's Association. Our association represents the 83 sheriffs that provide law enforcement services throughout the state. And based on the role that they play, we believe that they are significant stakeholders in this deliberative process designed toward the passage of these bills and the furtherance of public safety in the state of Michigan. I want to say that we're in support of Senate Bill 83H5 and House Bill 4145H5. But I think it's important to state that at the beginning, Senate Bill 83, as it passed the Senate, we were in opposition to. House Bill 4145, as it was initially introduced, we were in opposition to. I came here personally to thank Chair Breen and her staff for the hours that they spent in consultation with us as we worked through issues designed to make this bill something that could be actualized and operationalized by all of the attendant stakeholders. We believe that's in the best interest of public safety. We're very pleased and honored that our requests were taken into consideration as we move through this process, and I just wanted to express our thanks and our support for the passage of these bills. Thank you.
Thank you very much, Sheriff. It's been an honor working with you. The committee will now go at ease.
Mr. Abrams and Representative Brixey.
Thank you, Representative Edwards. I want to start by noting that these proposed bills embrace and account for due process while balancing the critical need to keep guns out of the hands of people who pose an imminent threat to themselves and others. Violence is multifaceted. It's not limited to schools. We are constantly reeling from one mass shooting to the next, and between those are suicides, which make up more than 50% of all gun deaths. Guns are the quickest and most efficient way to kill. Their proliferation and easy access make them the target and means for homicides and suicides. Of the 40 largest countries in the world, the U.S. is fourth for gun deaths, and from 2014 to 2020, gun deaths in the United States rose by 35%. Guns are now the leading cause of death for children. And I'm looking at you on the committee with children, with grandchildren, with nieces and nephews, and asking you if you can live with yourself if you refuse to take these steps. If guns made us safer and more guns increased our security, they would not be the leading cause of death in children. Less than 1% of violent crimes are stopped by a good guy with a gun. Armed citizens also lack training for high-stakes situation. They can make a bad situation worse. A more effective approach for preventing gun deaths is to enact strong laws and policies to keep guns out of the wrong hands. We often hear that these tragedies could be stopped by a good guy with a gun. An FBI study of 160 active shooting incidents from 2000 to 2013 found that one was stopped by an individual with a valid firearms permit. In contrast, 21 incidents were stopped by unarmed citizens. People might claim that they need a gun for defense, which is obviously true. But I note that a 2015 analysis from Harvard found that the likelihood of sustaining an injury during a robbery was nearly identical between people who attempted to defend themselves with a gun and those who took no defensive action. A gun is more likely to be stolen than used to stop a crime. In fact, guns are nearly twice likely to be stolen than used for self-defense. I would also like to point out that no mass shootings in the past 30 years have been stopped by an armed civilian. In fact, most of the incidents in the United States in which a single shooter kills 4 or more people, which is the FBI's definition of a mass shooting, do not occur in locations where guns are banned, but rather in private homes or public locations where individuals are free to carry guns. There is no evidence to show that mass shootings are carried out specifically by the locations in which guns are banned. In fact, a study shows that 10 states with the weakest gun laws have an aggregate level of gun violence that is 3 times higher than 10 states with the strongest gun laws. Some people say that if a person wants to commit suicide, they absolutely will, and you won't be able to stop them. And that is not true. Again, guns are the quickest and easiest way to kill. My sister, who slit her wrists back in 2018, is proof that that is true. People might say that mental health is the problem behind all these mass gun deaths and this gun violence. And mental health is certainly a component. But I would ask the committee to consider this. Other countries have mental health issues just like the United States does, but yet they do not have nearly the aggregate amount of gun violence that we do. We have the opportunity to do what is good and do what is right. We have the support of the Michigan Sheriff's Association. I have spent a lot of time talking to parents whose children were murdered at Sandy Hook, at Parkland, and people who have lost children due to domestic violence and accidents. And if I never speak to the parent of a murdered child, I will rest easy. I'd like to walk you through some of the changes that we have here. And specifically, we've had lots of testimony on the extreme risk protection order bills. We are now going to allow guardians as well as physicians, health providers to file a complaint if they wish to remove firearms from one of their patients. We are going to make the provisions of this bill applicable to individuals whether or not they own or possess a firearm. We are going to make sure that for the regular ERPO hearings, there will be notice and opportunity to be heard by the respondent. Due process will be considered. Ex parte hearings uses the highest standard of evidence, which is clear and convincing, and it must be demonstrated that immediate and irreparable injury, loss, or damage will result. There is going to be a streamlined process for law enforcement. We hear this all too often, in which law enforcement will be responding to a complaint. Often these are in the cases of domestic violence or a suicidal individual, and law enforcement has no mechanism at this point to take firearms from somebody who may be using that gun after they leave. We are now able to provide a mechanism which law enforcement will be able to call a on-duty judge or magistrate in that jurisdiction. They will have to explain the situation, and if it appears that there is an imminent threat of danger, law enforcement will be able to depart that situation with the gun in hand, leaving it less likely that a domestic violence incident will occur or that somebody will take their own life. For anybody that disobeys an extreme risk protection order issued by the court, that will be a felony. However, if somebody files a false affidavit, that is a misdemeanor. We are going to hold harmless entities, including law enforcement, if they transport those firearms and they keep them. We are going to provide a process for guns that are left in the hands of law enforcement after an ERPO expires. If they are not reclaimed within 90 days, they will be subject to the civil asset forfeiture laws. We are going to allow, due to capacity issues where law enforcement might not be available to accept a relinquished firearm, there will be an opportunity within judicial discretion for a judge to say that a person could surrender it to a federally licensed firearms dealer from a court-approved list that will be supervised by SCAO. We are going to make sure that we are able to execute these laws and enforce these laws in a way that is effective, that is efficient, that is equitable, that will save lives. And another way that we're going to do that is we're going to ask that SCAO collects certain demographic data, and it is going to be open up to researchers, including the Michigan Institute for Firearm Injury, so that we can receive a report and make sure that we are using these laws as effectively as we can. I have here also with me Representative Brixey, and I have Mitch Albers from the Attorney General's office. Before I have them speak, does anybody have a question for me? Mr. Albers?
Thank you, Chair Breen, Vice Chairs Edwards and Fink, and members of the House Judiciary Committee. As was noted, my name is Mitch Albers. I'm the Director of Legislative Affairs for the Michigan Department of Attorney General, and I appreciate the opportunity to testify in support of the proposals before you today and the efforts taken by this body to bring the bills before you. We believe these changes will help reduce gun violence while ensuring individuals' Second Amendment and due process rights remain protected. This is achieved by such changes as increasing the evidentiary standard to clear and convincing and increasing the frequency that respondents can seek modifications or terminations of ERPOs. The ERPO places a significant burden on courts that must be met before an individual's rights to possess a firearm is restricted. The court may not issue an ERPO unless it finds not only that the individual in question can reasonably be expected to seriously injure themselves or another, but also that the individual has committed acts or made significant threats. In this way, this law is practically the opposite of what was struck down in New York State Rifle and Pistol Association v. Bruin, and that law placed the burden on citizens to demonstrate good cause to be allowed to possess firearms, while this places the burden on the courts. Under the law, the default is that a citizen may possess a firearm, and only on a significant showing of risk of harm can a court temporarily restrain that right. The ERPO allows the person subject to the ERPO to demonstrate at any time that circumstances have changed and that the ERPO should be modified or rescinded. The restrained individual has the right to a hearing on a motion to rescind twice within the first year and twice and every year after that under the latest substitute. At a court's discretion, or an individual may also submit any other number of motions to rescind, and a court may review those and then either summarily dismiss them, or if they believe a change of circumstance has occurred after the first or second opportunity, to bring a hearing to determine whether the circumstances have changed. The ERPO legislation before you includes numerous due process protections similar to those that surround the issuance of a personal protection order, and in that way does not tread unfamiliar ground. We really appreciate the opportunity to testify and support this legislation. We certainly appreciate all of the efforts that have gone into getting this bills to you today and the collaboration and compromise that has occurred along the way. With that, I'm happy to take questions with the representatives.
Thank you, Mr. Mitch. We have a question from Representative Fink.
Thank you, Madam Vice Chair. I have a question. I mean, we could talk about a lot of different things in this, I suppose, but I'd like to ask about an issue you addressed at some length here, about a motion filed by a respondent attempting to, or an individual restrained attempting to lift one of these orders. I have two questions about it. The first is, what is the reason, and can you show me an analogy somewhere else in the law for the limitation based on how long the order has been in place for the number of motions that the respondent can file? I think it's true that in any case, the court can already direct a party not to file repetitive motions without new evidence, without something new for the court to consider. Why is it that the court can't rely on the powers that it uses every day in this case?
I'm not sure I'm following. So the statute or the proposed bill before you specifically outlines that there will be one instance within 6 months and then another instance in 6 months where the individual is entitled to a hearing to show that there has been a change of circumstance. All of the other motions they can file are allowed for a judge to review in case something has changed. So there are two specific instances where not only a motion will be made, but a hearing on that motion will be heard.
Yeah, so I think this is my question. I mean, we can talk about the fact that the respondent. That's the second part of my question, is whether you can whether you can show me something analogous in law where the burden is shifted to the respondent in a situation like this, where the respondent will now bear the. I mean, we had testimony, I think, from both a former judge and now prosecutor in Oakland County and a judge from Macomb County that this burden shifting creates a problem in their eyes. So if you want to speak to that, please go ahead. But the question I'm asking is, why is it that the statute has to say one motion per 6 month period? Why is it that if a respondent files a motion in the second month and something changes a couple of months later, why isn't the respondent able to file a motion then rather than having to wait an additional 4 months after the second month to file a second motion?
They are allowed to file a motion they're allowed to file as many motions as they want.
All right. So then what does this mean? An individual restrained under an ERPO may file a motion to modify or rescind the order at any time and request a hearing. The restrained individual may file one motion to modify or rescind the order in the first 6 months. If that motion's filed and denied in the second month of the first 6 month period, does this not prevent the person from filing a second motion in the fourth month of the first 6 month period?
No, because it says they can file a motion any time. That just then goes on to say that if after the first month filing a motion, or after the first motion in the first 6 months, or the second 6 months, that the judge may then review without holding a hearing and dismiss the motion.
Okay, and so my question is, why is it that we have this limitation I mean, I understand the person can file the motion, all right? The person's only entitled to having a hearing on the motion one time. My question is, why is that? And is there another place in law where we treat a litigant this way, where their ability to file and have a motion heard is different because of the nature of the case or whatever? Is there another area of law where we have a limitation like this?
Yes.
Can you?
So under the guardianship statute, in fact, an individual can be prohibited from filing a motion after a guardianship has been established for 180 days.
Can be prohibited?
Yes.
What does that mean, that the court has to make that decision to make the prohibition?
I'd have to refresh myself on the guardianship statute, but in there it does note that a judge does not have to hold a hearing on a motion that is provided a guardianship with before 180 days after the guardianship has been established.
Okay, perhaps we could look at that, talk about that afterwards. I appreciate it. And then just if you want to respond to the burden shifting and why it's appropriate for the respondent to bear the burden of having an order lifted after it's been in place, why doesn't the burden remain with the petitioner as it does in other contexts like PPOs?
I'd have to take a closer look at that, but I do know that we did lower the standard that the individual has to file. The respondent restrained individual does have to meet to a preponderance of the evidence, unlike the standard to establish a PPO or a ERPO, which is clear and convincing. So we did try to ease the burden, but also to not drag the petitioner into court at every time a respondent does seek to have their motion brought in, because then the respondent is the motioning party and the petitioning party to have the motion or the ERPO rescinded.
Okay, I think with the section I'm looking at, if you do want to look at it, section 7, sub 6, the restrained individual must prove by a preponderance of the evidence on one of those motions.
Yes.
That's what I'm.
But they are technically the moving party at that time.
Representative Fink, I would note also that in the 19 other states that have ERPOs, about half of them only allow one motion to rescind during the life of the order. The others have varying degrees of flexibility in there. But again, we want to make sure that we do not overburden the court with motions again and again and again. But I do believe this strikes a balance because, again, we have to prove by the petitioner has to use the highest burden of evidence, clear and convincing. But once the respondent is able to hopefully make a change in circumstances, they seek the mental health help that they need, or they are otherwise able to change what is happening so they no longer pose an imminent threat to themselves or others, that burden is downshifted to preponderance.
We do have one more question from Representative Wozniak.
Thank you, Madam Chair. Actually, two questions. Counselor, I'll go with you. I know your department's very sensitive to the issues of social inequalities on other bills that we've talked about. What have been the discussions about social inequality with these bills for the ERPOs that you have had?
I'm not sure I'm following. I think we believe that these bills, so one, data shows that these bills are used, or that ERPOs are used proportionally across demographics, and two, we believe that these bills will be able to save lives across communities, and that by taking away guns from individuals who want to cause violence themselves or others, that they will save lives in those communities.
All right. So when I'm talking about inequality, it's probably economic more than anything as to how a defendant would at some point get an attorney, retain an attorney, defend himself, take off time from work. And by the way, isn't there a clause in here that the employer has to be notified of this, which may cost him his position?
Only when the employer requires their employee to have a firearm when they in the course of their job. So if the employer needs to know that the employee can no longer possess a firearm. So that is the only circumstance.
Okay, and then
Representative Wozniak, I might be able to provide some clarity there.
yes, sure.
So first of all, if the respondent is a law enforcement officer, if they are required to carry a firearm under the normal circumstances and they cannot because of their position, they would be deemed unfit for duty and placed on unpaid administrative leave. What we did in order to protect that is we have specifically stated as the intent of the legislature, as we heard from Judge Jokic, that the law enforcement agency work with the judge to ensure that they do not suffer any loss of compensation or employment. As far as the demographic data and impact on communities of color, we have added, as I stated before, some data gathering provisions to include that information to be provided to research institutes because of what has happened at the federal level. We have a severe lack of data. And we don't have a lot of information on any disproportionate impact. But what I do know is that a study of all the extreme risk protection orders filed in Colorado, the short period of time in which they had, in all of them, Colorado is approximately 31% minority. However, 80% of the ERPOs were filed against white men. So the converse is actually true. And of all those, only 4 were found to be based upon a false affidavit, and in none of those instances did the judge actually grant the ERPO. I hope that provides some clarity.
Thank you. So to be clear then, there is no mandatory reporting of a defendant to an employer unless they're utilizing a gun in their employment?
Correct.
Okay. And then lastly, for the counselor again, I know you have to resolve these issues inside the bills, but how do you see this as conflicting or being in step with the Second Amendment of the Constitution and Article 1, subsection 6 of the Michigan Constitution?
I am not a constitutional scholar, but I will note that that the Supreme Court has recognized that some restrictions on firearms are acceptable, and most recently in Bruin noting that in sensitive places, restrictions on firearms are acceptable. And so while the statutes do say a regulated militia, so we would note that while there are certainly Second Amendment concerns, we have tried to implement as many due process checkpoints to make sure that Second Amendment and due process are protected under this legislation. And so there are, the ability to, put restrictions on the right to own and possess a firearm.
So your discussion would be the same for Article 1 of the Michigan Constitution?
It is similar. I am not, again, a constitutional expert, so I will refrain from opining any further.
All right. Thank you.
Thank you, Representative. We do have time for one more question, given the time that we've been going through. Representative Diebendorf?
Yes, I appreciate my Republican colleagues bringing up concerns related to marginalized communities. I just wanted to confirm and acknowledge that that you all as sponsors have worked very hard on making sure that we are satisfied with that particular concern, and I really appreciate that. And that is why and how the data collection piece was inserted into this bill. And I am satisfied with that and really, really grateful for your work on that. And I just want to confirm, because so that my colleagues know, the data collection piece is one way that we are addressing that. Because we're not addressing it in additional ways, because a lot of the concerns have to do with implementation, we will be addressing any concerns about inequitable implementation with other legislation. But it was not appropriate to address it in this bill, correct? Because implementation is a whole different animal.
That is correct, Representative Diebendorf. These bills in and of themselves are equitable, but they could be inequitable if they are inserted into a broken system. And so I'm eager to work across the board with law enforcement, with communities of color, in order to make sure that the implementation process is as fair and equitable as possible. We have some great partners at Everytown, with Brady, with the Giffords organization, that have done this in other states in order to make this as fair as we can be. I also note that in studies that we have seen, there has not been any an inherent bias, but there is sometimes implicit bias within law enforcement, and I know that our partners in law enforcement have been eager to discuss a resolution to finding solutions to these problems as well. Thank you.
Representative Brixey, you now have the floor.
Thank you, Madam Chair. And thank you, Representative Breen, for all the effort that you've put into this extreme risk protection order package. As Representative Breen stated, it's clear that we have a problem with gun violence in this state and in our nation. This is a uniquely American problem that we're facing. Our children are being forced to grow up in a world where they're put on the front lines every single day and expected to keep themselves safe, even at school. They have to learn how to do lockdown drills and barricade classroom doors while they're learning fractions and long division. And many of these kids have spent their whole lives in school with their eyes on the exits and wondering, is it inevitable that they're going to be the next victims of a mass shooting? Students in my district from Michigan State University have been asking me nearly every day to advocate for significant change that will impact real people and real lives every day. The tragedy at MSU occurred one day short of the 5-year anniversary of the horrific attack in Parkland. This example is a very good example of good that could come from extreme risk protection orders, as the person that carried out that fatal attack had numerous encounters with the police and was known to have weapons and to have made threats, but there was no mechanism in place to take steps to prevent him from carrying out his chosen path of tragedy. I think that every one of us sitting here probably has been touched by suicide or by other type of gun violence. And when we know that 60% of deaths by firearms are people taking their own lives, the importance of this legislation is paramount, because the vast number of people that will be helped by this legislation are those folks who are at risk to themselves. Having had personal tragedies in my own family, I very much look forward to seeing this legislation pass so that we can help our loved ones in their darkest hour and take steps to prevent tragedies from occurring rather than cleaning up messes after they occur. So I thank you for your consideration and hope that you'll be able to support the package.
Committee will go at ease. I note that we have a number of people who have submitted cards. The committee is back to order. We do have a number of people that have submitted cards, some wishing to speak, some not. Please note that all the cards will be recorded in the committee minutes. Due to time constraints, we are not going to be able to hear from everybody, but we appreciate your input. And again, your testimony will be recorded in the minutes. There is a H5 sub for House Bill 4145. I will take a motion from Representative Devendorf to adopt the sub. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards. Pass. Carter. Yes. Hope. Yes. Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel. Pass. Wozniak.
No.
Outman.
Pass.
Johnson. No. Madam Chair, you have 7 yeas, 2 nays, 4 pass. The substitute is adopted.
I will now take a motion from Representative Hoskins to report House Bill 4145 as substitute H5 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Pass.
Carter.
Yes.
Hope. Yes. Arbit.
Aye.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, 1 pass. House Bill 4145 is reported with recommendation as substitute H5.
Thank you. I will now take a motion from Representative Sergalu to report House Bill 4146 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 4146 is reported with recommendation.
Thank you. I will now take a motion from Representative Edwards to report House Bill 4147 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope. Yes. Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 4147 is reported with recommendation.
Thank you. I will now take a motion from Representative Carter to adopt the H2 sub for House Bill 4148. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. The substitute is adopted.
I will now take a motion from Representative Hope to report House Bill 4148 as substitute H2 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 4148 is reported with recommendation as substitute H2.
There is an H5 sub for SB 83. I will take a motion from Representative Sergilou to adopt the sub. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Substitute H5 to Senate Bill 83 is adopted.
Thank you. I will now take a motion from Representative Hoskins to report SB 83 as substitute H5 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Senate Bill 83 is reported with recommendation as substitute H5.
Thank you, Madam Clerk. I will now take a motion from Representative Devendorf to report SB 84 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Senate Bill 84 is reported with recommendation.
Thank you, Madam Clerk. I will now take a motion. I'm sorry. There is an H2 sub for SB 85. I will take a motion from Representative Arbit to adopt the sub. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman. Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Substitute H2 is adopted.
I will now take a motion from Representative Hope to report SB 85 as substitute H2 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Senate Bill 85 is reported with recommendation as substitute H2.
Thank you, Madam Clerk. I will now take a motion from Representative Edwards to report SB 86 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. Senate Bill 86 is reported with recommendation.
Thank you. Before we adjourn for the day, I would like to note that the Michigan Fraternal Order of Police has indicated they are in support of the package. I would like to thank the committee for their patience and for everybody who's testified on these matters. Seeing no further business before the committee, we are adjourned.